This is a collaboration between Legal Listening and the Provincial Court of British Columbia. This article provides general information only and should not be used as authority in court proceedings or as a substitute for legal advice. You can find us online at legallistening.com, on Twitter at legallistening, or email any inquiries to legallistening@gmail.com. Enjoy! How can I get a court order on an urgent family matter other than a protection order? Originally posted on June 1st, 2021. Getting a court order on most family matters in BC Provincial Court takes time. You must file an application and serve it on, that means deliver it to, the other party. Then they have 30 days to file a reply before you are given your first court date. Depending on your court location, you may have to take other steps as well. But sometimes, either before or after this process has begun, an urgent issue arises. If you have an urgent need for a court order, there are ways of getting your application into court more quickly. This article will outline procedures for getting a hearing quickly if you are asking for an order in a priority parenting matter, an order preventing a change in the location of a child's residence, an urgent court order in any other type of matter. Procedures for getting an urgent protection order if you fear family violence or canceling a protection order that was unjustified and made without notice are outlined in other eNews articles. How can I get an urgent protection order or set one aside? Priority parenting matters. The definition of priority parenting matters in the BC Provincial Court Family Rules includes various matters relating to actions by guardians and removal or relocation of a child. Priority parenting matters include these actions by guardians: a guardian's consent to health-related treatments for a child, if delay will result in risk to the child's health, including giving, refusing, or withdrawing consent; a guardian's application for travel with a child or participation by a child in an activity if consent is required and is alleged to have been wrongfully denied; a passport, license, permit, benefit, privilege, or other thing for a child if delay will result in a risk of harm to the child's well-being or their physical, psychological, or emotional safety or security. They also include these matters involving removal or relocation of a child, a change in location of a child's residence, or a guardian's plan to change the location of a child's residence, if there is no written agreement or order about parenting arrangements for the child, and the change of residence can reasonably be expected to have a significant impact on the child's relationship with another guardian. The removal of a child under Section 64 or 77 sub 2 of the Family Law Act, matters relating to interjurisdictional issues under Section 74 sub 2 sub c of the Family Law Act, the return of a child alleged to have been wrongfully removed or retained under the Convention on the Civil Aspects of International Child Abduction, or the return of a child alleged to have been wrongfully removed or retained under the Convention on the Civil Aspects of International Child Abduction. See Provincial Court Family Rules Part 1, Division 1, Section 2 for the exact wording of the definition of priority parenting matter. The rules allow parties to apply for orders about priority parenting matters using an application about a priority parenting matter, with just 7 days' notice to the other party. Only the matters listed as priority parenting matters in Section 2 can be brought to the court using this process. If you need an urgent order for another type of matter, see Other Types of Matters later in this article, or the eNews about protection orders on the court's website. It may be possible to have a priority parenting matter heard by a judge with less than 7 days' notice if the matter is urgent. You would use an application for case management order without notice or attendance to ask a judge to shorten the notice period and follow the instructions on the form. See Provincial Court Family Rules Part 5, Division 4 for the rules about priority parenting matters. Changing location of a child's residence. The forms and procedures used when there's a dispute about changing the location of a child's residence, also called relocation of a child, depend on whether there is an existing court order or written agreement about parenting arrangements. No order or agreement. If there is no existing order or written agreement and you are requesting an order about parenting arrangements, you use an application about a priority parenting matter, to ask for an order preventing relocation. Existing order or agreement. If you have a court order or written agreement about parenting arrangements, you file an application for order prohibiting relocation of a child. See Provincial Court Family Rules, Part 5, Division 5, Rule 80. Other types of matters. Sometimes people need an urgent hearing in a matter that is not a priority parenting or relocation matter and doesn't involve a protection order. In that case, you can apply for a case management order to shorten the notice period or excuse you from serving your application on, delivering it to, the other party. Some applications for case management order can be decided by a judge based on the written application, without requiring the parties to attend court. The application for case management order without notice or attendance contains a list of orders that can be requested without notice and attending court. For orders that require court attendance or have all parties consent, use the application for case management order. See Provincial Court Family Rules, Part 5, Division 2 for rules about case management orders. FAQs about urgent family matter proceedings. Do I need a lawyer? You don't need to have a lawyer to make applications in court or to file court documents, but you may find it very helpful to speak to a lawyer about your problem. A lawyer can give you advice about your legal issues and can help you understand court forms and processes. They can also help you prepare for a hearing or other court attendance. See Getting a Lawyer or Legal Advice on the Useful Links page of the court's website for help finding a lawyer or legal advice service. It includes free or low-cost options. How should I prepare for a court appearance on an urgent matter? Time in court is limited, particularly at first appearance on an urgent application, so it is very helpful for the judge to be able to read any relevant documents before your court appearance. Any affidavits or documents you prepare should be as short as possible. You can provide them to a judge by filling out an affidavit in the court registry and delivering a copy of it to the other party with your application. An affidavit should include the relevant facts. Relevant documents can be attached to it. You may also file affidavits from other people who have heard or seen things that are relevant to your application. See eNews article or listen to the podcast titled The First Rule About Evidence. It must be relevant. Come to court prepared to discuss your family law issues and, if possible, to resolve them. Consider in advance what you think the outcome should be, and if the issues are related to a child, what would be in the best interests of the children. Section 37 of the Family Law Act states that the judge and the parties must only consider the best interests of the child when making orders or agreements about guardianship, parenting arrangements, or contact with the child. What can I expect at my first court date? Some first appearances in family matters are being conducted by telephone, audio, or video conference. See the Virtual Conferences and Hearings page of the court's website for more information. At a first court date on an application for a priority parenting order or an order prohibiting a child's relocation, the judge will decide whether the issues can be decided quickly by hearing brief evidence and or reading the affidavits that have been filed. If that's possible, the judge will consider the evidence and make an order. Even if you have filed an affidavit, the judge may still require you to provide other evidence by testifying at a hearing. But if the matter is more complicated or requires more evidence, the judge will refer you to a judicial case manager to set a date for a hearing, also called a trial. An interim, temporary order may be made to address any issues that may arise before the hearing. If the time estimate for your trial is longer than 1 day, you might also be required to attend a trial preparation conference to ensure you are ready for trial. If an order is made, will I get a copy of it? Yes. If an order is made, it will be typed up and signed by the judge, and then both parties will receive a copy. If the parties have lawyers, one of the lawyers will prepare the order and send it to the court for signing by the judge. Then the court registry will send copies to the lawyers to give to their clients. If the parties do not have lawyers or are using the services of duty counsel, the court registry will prepare the order and send it to the parties. This article provides general information only and should not be used as authority in court proceedings or as a substitute for legal advice. eNews is a publication of the Provincial Court of British Columbia. Learn more about the court and subscribe to eNews at www.provincialcourt.bc.ca.